as British singer Ed Sheeran did not steal key components of Marvin Gaye's classic 1970s tune Let's Get It On to create his hit song Thinking Out Loud. A jury said that with a trial verdict Thursday, prompting Sheeran to joke later that he won't have to follow through on his threat to quit music if he did lose that lawsuit there. Mark Ostro, senior counsel at Romano Law in New York, does join us now live to talk more about all of this. Thank you so much for taking the time to be here tonight.
Oh, my pleasure.
So first off, what did you think of this verdict? Is it something that we expected would happen?
Well, it's a jury, so you can't really ever know what to expect. But I think that the verdict is absolutely consistent with recent similar high-profile cases, including the Led Zeppelin case and the Katy Perry case. And I do believe that the jury made the right decision based upon what was at issue in this case and the governing copyright law principles.
And as we said, Ed Sheeran actually said that if he lost, he would quit music altogether. Do you think that was a show of how confident he was that he was going to win, or was he really just saying, I'm out if I lose?
I think it's the latter. I don't think it was a show of confidence at all. Again, you don't know how a jury is going to decide, and I do think that he was genuinely frustrated, and he felt that a verdict like this would undermine the whole songwriting process for artists, not just him, but all artists.
And if Sheeran had lost, would that have likely opened the door to other lawsuits just like this one from other people who say, hey, this person stole my music, because it kind of sounds the same?
Absolutely. If the jury had found Sheeran had infringed, and especially if the verdict were upheld on appeal, or even if the parties subsequently settled to avoid a lengthy appeal process, it would further open the floodgates to major suits against artists where there's any claim of similarity that could be made.
And Sheeran actually played the song there in concert. We heard one of the jurors say it was a great concert. Can something like that, let's say a celebrity performing in the courtroom during the trial, affect the jury's decision?
Well, I think a celebrity artist performing in the courtroom is absolutely going to have an effect on the jury. But depending upon the nature of the performance and the credibility of the artist, that could either be positive or negative. In this case, it seems to have been a positive influence because part of what Sheeran was doing was demonstrating his songwriting process.
So when selecting a jury, would they ask potential jurors if they're a fan of Sheeran? Does that actually matter? I know that when they pick juries, they normally ask these kinds of questions. So in a case like this, would they have asked if, the potential juror was a fan of Sheeran's music?
Well, if I were the plaintiff's lawyer, I certainly would not want a juror that was predisposed to rule in Sheeran's favor. So if I were picking the jury for the plaintiff, I wouldn't want an ardent Ed Sheeran fan hearing the case.
Do we see cases like this one over music happening very often? I feel like you mentioned a few of them, and I've heard quite a few of them over the past several years. Is this that common, and how often do they end up going against someone like Ed Sheeran?
I think, first of all, claims are frequently made. Most of these things don't go to court. If there really is a viable claim, they typically get settled and we never hear about it. But again, I believe that the Blurred Lines case, which also involved a Marvin Gaye song, really was the first time that you had a jury verdict that was upheld on appeal where there wasn't something that you could really point to that was actually infringing, like the melody and the lyrics, even though the appellate court said that they weren't finding that you could copyright a groove or a feel. That was the effect of the Blurred Lines case, and that really started a wave of these kinds of lawsuits. But as I mentioned, from some of the other cases, like the Led Zeppelin case and the Katy Perry case, there the defendants prevailed. So the tide has been turning, and now with Ed Sheeran, you may see these cases still filed, but I think I think the spigot is being turned to what had been a fire hose to maybe now being a garden hose for these kinds of cases.
All right, Mark, thank you so much for taking the time here to join us. Is there anything you want to add before I let you go?
other than to reiterate that despite what seems to be surface similarities between the cases, what really you have to have are copyrightable elements that are taken. And what was mostly in common was the chord progressions between the two songs. And chord progressions are building blocks of songs that are freely to be used, and so you can't build an infringement case based upon non-copyrightable elements in songs.
All right, Mark, thank you again for taking the time here to join us. We appreciate it.
Oh, it was a pleasure being here. Thank you.